She Entrepreneurs, Foundry 2020, Session 1, August 5th. Good evening, everybody, here in Israel. Good morning, Gwen and Gail in the Silicon Valley. Thank you all for being here. According to Quantopian, a Boston trading platform, Fortune 1000 companies that had women CEOs between 2002 and 2014 generated 348% return on investment, ROI, versus only 122 of the S&P index, that is almost 3 times better returns. Those of you who attended the MIT Enterprise Forum She Entrepreneurs webinar 3 weeks ago heard this from Gail C. Edwards, chairman of ARI, Angel Resource Institute, our keynote speaker and program leader. The webinar, mind you, was posted over the State Department Facebook page with 6,100 views last time I checked. According to further comparison carried out by ARI, Angel Resource Institute, share price performance of companies with female participation in senior management measured between 2009 and 2016 was twice as good when women held 50% of senior positions. Yet, as of January 2017, just as this research was compiled, only 5% of S&P 500 companies were led by women CEOs, and women only occupied 20% of board seats on Fortune 500 companies in 2016. Mind-blowing, isn't it? Today, we are launching the MIT Enterprise Forum of Israel She Entrepreneurs Foundry 2020, in which we will work with you to strengthen your offering, your value proposition, make sure all necessary ingredients are in place. This requires work, and hence those of you who are admitted will be with us on a weekly basis every Wednesday, supported by our incredible Foundry leaders and our dream team of mentors. We will do that, and we'll do what we can to position you for scale. It's all about scale. Today's session is different than other sessions in that we've invited all relevant applicants, that is applicants that are not non-profits. We had 2 of those, and are from Israel. We had a couple of those as well to join in. We will make the final decisions regarding admissions on Monday, August 10th, and thank you for your patience. It is my privilege to now introduce our She Entrepreneurs Program Leader, Gwen Edwards. Gwen co-founded Golden Seas, Silicon Valley, which is now part of a 300-person national angel investments network in the US. Over the past 15 years, they have invested over $139 million in companies that went on to raise over $1.2 billion. Gwen also chairs the Angel Resource Institute and brings her intense focus on gender and actively researching and teaching women angels and investors on how to build successful ecosystems for women and men alike. Gwen will discuss Foundry 2020 goals and means. Good morning, Gwen. How are things in Silicon Valley today?
Great, great. Hi, how are you all? Just a little foggy here, but yeah, it's so exciting to be part of this global community. It's just fascinating to see how much women are doing all around the world. It's just incredible. And I love the fact that you referenced those quotes, Ayla, because it just reminds me that while we're working to affect change at the top, at the current institutions, the Fortune 500, the Fortune 1000, you know, that takes change. Everything takes systemic change. But while at the same time, we all have talents and abilities, and we're going out and forming new companies. And so we want to work at the early stage and the late stage and make sure that women are seen and represented and have the full opportunity to put all of their talents, their amazing brains and abilities and persistence So that's why we're here. And we also know that women can help other women. And Ayla's put together an incredible group of mentors for those of you who are in the course over the next 12 weeks, almost 8 weeks, I guess. It ends September 30th. So we're going to be covering everything from how do you understand, how does an investor think? So everything from how do they think? So how do you know how to be more sensitive to what they value as you build your company and know when to present? And right up to valuation and how do you think about exit? So everything from soup to nuts and how you pitch. So it's a lot to cover in a short time, but you'll get a taste and they'll have homework. You can do as much as you can. You can refer back to it. So it's going to be wonderful. I'm really looking forward to participating with you over this next period. Joining me in teaching is Gail Gannon, who is another wonderful person from Silicon Valley. And Gail, in addition to also having been an entrepreneur and also does angel investing, has an even more intense focus than I do on the healthcare sector. So we both bring tech, and I bring some healthcare IT. She's spent almost her entire career in the healthcare sector. So it's a wonderful way to also round out what we bring as a team to all of you with a focus on femtech and broader tech. So with that, today we wanted to start the class actually with this wonderful lecture by Heidi Brun, and focus on IP and why IP and understanding your brilliant ideas and how to protect them is so important, whether you're just starting out, you've just incorporated, or actually, believe it or not, even after you've been acquired, how you protected your IP can come back to bite you. So it's something that's throughout the process you really need to be aware of. So I'm going to not say more at this point because I'll be front and center for most of the other sessions along with Gail. But let me turn this over now to Heidi so that you get the full hour of information about IP, and we'll be engaging and asking questions as well. Thank you. Thank you, Ayla.
Thank you, Gwen. Thank you so much. So as Gwen mentioned, this is going to be a session about IP, intellectual property, which according to Wikipedia is a category of property that includes intangible creations of human intellect. Now, before we start, you're most welcome to send IP-related questions on the Zoom chat to Heidi, our speaker, so that she can prepare some answers for you during the talk. And this is my view. Of course, it's not Heidi's, but my view is the field of IP can be rather mundane. You know, you file again, add claims, add the jurisdiction. It's a lot of hard gray work. And so you do this and you write your provisional and you ask yourself, do I need a patent attorney next to me or not really? And then the year goes by and, oh my God, what do I do now? And do I file where? And how much is it going to cost? And do we want to file this, that, and the other? And how much time and how much money is this going to cost us along the life of the company? And this is the big question, to file or not to file, when to file, what to file, etc. And Heidi happens to be one of Israel's most respected patent lawyers or patent attorneys. She's also an MIT alumni. So a few words about Heidi. An MIT graduate, which with multiple degrees in mechanical engineering, Heidi has been a patent attorney in Israel and the US patent agent for 30 years. Heidi is an expert at working with investors, inventors, male or female alike. Their visions are often complex, full of jargon, and poorly explained. Trust me, this is the case. Heidi and her team of patent writers and draftsmen turn these sketches into elegant and defensible patent applications. An MIT graduate with multiple degrees, we said that. Heidi has helped many clients, large and small, to manage their patent portfolios, as well as budget them. Over the years, Heidi has written patents for dozens of success stories within the Israeli high-tech field, including Sci-Fan, Wix, GSI Technology, SodaStream, Given Imaging, IBM Vocaltech, and Cytex. I don't know how many of you know these companies. I mean, how much did PepsiCo pay for SodaStream? Over $3 billion, was it? Something incredible. Given Imaging was floated on NASDAQ. They got to a valuation of $1 billion. Vocaltech was the company that started the communication over IP, actually. Cytex was Israel's most impressive tech company in the 70s and 80s, beginning of the 90s. I don't have to tell you about Wix or IBM. Sci-Fan was a kind of a unicorn. Okay, at the time we didn't have unicorns, but it was a company that was privately invested, and I think the last investment was at a valuation of $400 million, which was huge at the time. And Sci-Fan is one of two companies that were involved in very, very interesting IP trials. And as mundane as IP may seem in the beginning, all of a sudden it flashes and bang, it's wartime. And then you have to look back and to make sure you've done everything right. So Heidi will tell us a little about that. Heidi is also a member of the MIT Enterprise Forum Management, and she will discuss the IP timeline and the financials of IP to the dollar-savvy entrepreneur. Heidi, there you go.
Thank you. And I'll just get my, second. I'll get my talk up. Everybody see the slides? Okay. Ella, really, thank you very much for the introduction and the opportunity to be part of this Femtech Foundry. As you said, I don't really agree that IP is mundane. To me, it's incredibly exciting to learn about new companies and new technologies, new products. Each invention is a new challenge, how to protect it, how to explain it, and why it's so wonderful, just like children. I plan to just talk about timelines of business and patents, but I'd like to start actually with some patent stories. There's a timeline for this talk as well. When you start with a company, you start a company because you have an idea. You have an idea how to change the world. You have an idea how to make something. Sometimes you have a problem that you'd like to solve, but you have a direction of how you're going to go and try to solve it. And you want to protect that idea. You don't want anyone else to take it because it's your baby. Whether you think about it that way or not, it really is. You want to protect your baby. And when I gave birth to my first child after a long period of not having children, we had a chat at the firm, Eitan Perlotzer and Tzedek, where I worked at the time, about how one would protect the child. And being IP folks, we talked about IP kinds of protections. We could have copyrighted her, trademarked her, patented her. And I suggested that copyright was just for too many years. That's 70 years in some countries, 150, 120 in the US. Trademarks also you can have forever, but it would be a great thing to have your children or your own, protect them for forever. But it seemed to me the more appropriate one, and I'm a patent person, so of course I thought to protect the patent, to define the essence of who she was, and to be willing when she turned 20 to give her to the world and to let everybody else enjoy her as much as I did, and that's what we did. Ella talked about Sci-Fan. As I said, I worked with Eitan Perlotzer, Cohen and Tzedek. Tali Eitan is the Eitan that's there, and her husband Boaz Eitan started Sci-Fan while I was there. And I was very involved with their patents, and I was involved in their case when they went up against AMD. Now, Sci-Fan, when it started, being a small company, did their search, wrote their patents, they knew about patents, they got an issued patent, and when they went to license it to AMD did not want to spend the money on that license. So AMD spent a lot more money doing a search and found a patent that was very close. And according to AMD, it invalidated their patent. This is very scary for a young company that was going up against such a large company. And I helped them realize the source of the difference, why that piece of prior art that the AMD found, although it was very close, just wasn't quite the right thing. That product in the patent that AMD found, it didn't work commercially, and Cifans did. And at the time that we were doing this court case, we were also writing more patent applications, and I was writing one that really, for all of us, finally explain what that real difference was. Something which generally happens is you work with your product, develop it more and more, you begin to understand it so much better. So the initial claims, you might want them to be broad, but having very specific claims to what you build commercially is also very important. Another case that I got involved with was when Lucent came calling. This was in the 90s. Lucent discovered that there are a lot of tech companies in Israel, and they came and said, you're infringing these 8 patents. So panic. We go and we try and figure out what they, are they valid, or are we infringing them? Maybe we're not doing all of what Lucent thought we were doing. We got up there and I explained to Lucent, oh, this patent isn't valid, and this patent, we're not doing that, and so we're not infringing any of these 8 patents. Lucent said 2 things. One, okay, maybe you managed to invalidate that particular patent, but look at the dependent claim, look at sort of a narrower claim, you're infringing that claim. And we all went, oh. Then they said, and okay, you got out of these 8 patents, we have another 8 patents, and another 8 patents, and another 8 patents. We can keep at this for the rest of your lives if you want. We've got thousands and thousands of patents. So a huge portfolio of patents is extremely useful because you can find something that you can argue over, and it's not worth the money. And so my company caved and paid them the money that they wanted. And their license could have been less because they could have given access to their patents in what's called a cross license. They didn't have them, and that's about the time that the Israeli patent world, the Israeli technology world, realized that we better get patents. And it's not enough to just have one. It works better when you have a bunch of them that cover different aspects of what it is you've invented. So now let's go discuss how that affects your business. Your business is running along. There are times when you're thinking about IP, and there are times when you're not thinking about IP. Obviously, when you start your company, you're thinking about IP. If you have an IP-related, an intellectual property-related invention, or maybe you've got branding that you want to do, that's more trademarks. You're writing software, that's copyrights. You need to know about these and set up your company and your company's legal documents so that they're all covered. So, you want to make sure that your company owns the patents, owns the copyrights. Trademarks a little less of an issue, but copyrights and patents need to be taken care of properly. And we generally know how to do this for employees, contractors, maybe yes as well. But when you work with folks like, I forgot the name of the term, I apologize. Contractors online, where you're just working with their system, you may not actually review the contracts that carefully. Another time that you will pay attention to IP is, well, when you came up with a big invention, a big idea, you will think about it and handle it. But you're going to be forced into dealing with IP and IP issues when there's an investment into the company, because the investors are going to be asking questions. They want to know, well, is it patentable? Is it really worthwhile? Are you infringing anybody else? Do you own that technology? Did you take care of, do you have all the assignments that I was talking about before? Do you have them all in line? Did you forget anybody? Those kinds of questions invariably come when you want the due diligence to finish quickly, and any kind of error in the eyes of the investor will take time to fix, which you usually don't have. Another time, of course, is when you're selling the technology, or you're buying the technology, or you're licensing it. These are times when you need to make sure that the contract properly covers the patents and the copyrights, the trademarks, whatever it is that sort of comes with the package of that technology, that comes with the protections that you either manage to buy or that you license out to other people. This is also relevant for joint development arrangements. I had one client where a big company was giving them a lot of money, and so the joint development arrangement was that all of the inventions belonged to the big company, except for the stuff the little company, my clients, brought to the table. And then we always kept having questions. Well, is this new idea part of the old stuff or part of the new stuff? Is it really new, or is it really just an extension? We filed, a child application of one of of their background technology. Is it theirs? Is it ours? There was all this discussion as to what is included, what isn't included. I know Microsoft and Honda have accelerator programs, and those accelerator programs have to handle the question of what to do with the intellectual property that comes up as a result. Does it belong to Microsoft and Honda? Does it belong to the company? Does it belong to them both together? How do you handle it if you want to share the technology? And so on. So these are the kinds of arrangements you have to think about as you're going into these kinds of arrangements. Most lawyers know the basic structure of how to handle them. They don't always know the specifics of how to get them registered at the patent office, and that's my job. Okay, so that's talking about it in terms of when the business needs to pay attention to IP. But there are patent timelines that are very difficult and very set, and those are what I want to talk about. That's most of the remainder of this talk. So let's start with what I said before, your baby. You had the idea. Are you seeing my, hold on a second. Do you see my, my cursor? I don't know how much you see, whatever. You have an idea, that's the light bulb. And what do you do when you have an idea? You talk about it, you think about it, you develop it, you try and get investors if you haven't yet started up a company. If you're inside of a company, it's generally easy. You keep the secret stays within the company. But if you're a startup working with an idea, you want to start up the company, you want to bring in investors, you want to find out how to develop it, you need to hire people to work with you. All of these things happen, and often you don't know if it's worth the money spending on a patent application. So you kind of wander around with the idea for a while, and then once you know you're comfortable with it, you know that you're going to be able to go forward with it, that's the point where you're going to start the company and you're going to invest the money in a patent application. However, the patent laws say that you have to file a patent application before you talk about it, before it becomes secret. This is registered in the patent law as novelty. It has to be new, not generally new, but specifically new, i.e. it was a secret on the day that you filed it at the patent office. So in the situation that I show here, where you talk about it before you get to the patent office, that's what this document looks like, you're not going to be able to get an issued patent on your idea, okay? You might be able to get an issued patent on some of the implementation details that you never told anybody because maybe you didn't know about them yet, or because you didn't ever want to tell anybody how you were going to build it. But you're not allowed to file a patent application on something you've talked about. So the broader claims, the broader concepts, you wouldn't be able to get. This is a problem, particularly for startups. And so the US, though, has a different idea, okay? So the US Patent and Trademark Office, the laws of that they work with, says you have a grace period from the time you talk about it and make it publicly a public disclosure, you have 12 months to get to the patent office. If you get to the patent office during those 12 months, it's fine. We will not consider your own publications against you. Okay, I don't know if any of you know about the new law that went in 2012-2013, where the US Patent Office changed and made significant changes to the laws, but the grace period used to be against everybody's publications, and now it's just your own publications, but that's the part that we care about. We do not want our own publications to come against us. So in the US, you're fine. And this is one of the reasons why an awful lot of our clients file in the US. First, because they've made their idea public, and it's only in the process of making it public that they discover that it was a really good idea, not just a good idea, but a really good idea. And as a result, they really need to file a patent application, or they want to file a patent application. This doesn't work for the rest of the world, because the rest of the world says you have to have filed your patent application before you talk about it. So what do? How do you get those rights? So the answer is file what's called a provisional patent application. And in fact, I should say here a US provisional patent application, because it's a concept that exists in the US and is beginning to move into other countries as well. But it was originally a US concept, and most people file in the US because they're going to be filing there anyways for other reasons. US provisional applications are cheap and easy to file. The Patent Office does not charge an awful lot of money on it. And they're really, the process of doing it online is very easy, very simple. Anybody can do it. So in general, people just file before presenting an idea. And because a provisional does not go through examination, therefore any of the rules that may exist for them don't matter, because nobody's ever going to say, you know, you didn't do what you were supposed to do. And provisionals only last a year. I'll talk about that in just a minute. But most people, what they do is they say, okay, I have to file something. And so you file whatever you have, a slide deck, a white paper, technical spec, whatever it is that you've prepared, you just file it. And you don't have to write any claims which define what the invention is. You just have to file something in order to get that date. You don't need a patent attorney. There's no requirement that a patent attorney be the one that's filing the application. So most people do this. Let's see what happens. Okay, so see, we filed the provisional patent application, and then we talked about it. Because the provisional application was before our publication, our publication was fine. We didn't have to keep things secret. Once you file a provisional, you don't have to keep a secret anymore. So that's okay, as long as at the end of the year, we convert the provisional into what's called a US non-convention application. It's the full application, and that full application is the real one. You have 1 year from your provisional application to convert it into a real application. And that way, any of their disclosures don't matter. Nobody sees them. Nobody knows about them. It's fine, okay? At the same time, there's another 1 year. We have the grace period 1 year. We have the provisional 1 year. Now we have what's called foreign filing, which is you file in a first country. This is what we call the priority filing. This is filed in the first country. And according to the Paris Convention, which is a fairly old convention, it was in the 1880s, you file the first filing, and then within 1 year, once again the 1 year, you can file abroad. So I've listed the US, Japan, and Europe as being sort of common countries people filing. When I first made these slides, Japan was very common. Nowadays it's more China. But what happens is that these foreign applications get priority back to the date of the priority application, which means that if the examiner finds a piece of prior art, a document that he thinks is similar to what you're doing, that falls anywhere in this period after you filed the priority application, he can't cite it against you, because you can go all the way back to your priority application. I've listed here another country called the PCT. It's not a country, it's the Patent Cooperation Treaty. It's a later treaty from the 1970s. And it came because there were certain problems with this system. And the problems are really more the problems of startups, but also any sort of not well-funded project. 1 year is not enough time to file your initial application, develop the product, check out that it's worthwhile, and have enough money, enough budget to be able to do something with it. So invariably at this 1 year point, clients are struggling with money issues. So the PCT said, look, let's create an arrangement by which we file in a single place, that's in the PCT. And it's as if you file, and it's called the International Application, and it's as if you filed in all the countries of the PCT on that same day, and you close out your priority. You've taken care of all of your foreign filing applications. You're in the PCT, and the PCT lasts another 1.5 years. So it lasts actually not a 1.5 years from when you file, but until the 30th month from the priority application. That's the way it measures. That way, if you file in the middle, it's fine. The PCT also does something else. When you file in many, many countries, after 1 year from your priority application, you very rarely hear from an examiner. So you don't know if it's worth spending all that money to file it in lots of different countries. What if there's a piece of prior art that knocks you out completely? Why did you spend all that money in all those countries? So the PCT will give you a search, an initial search, and nowadays also a written opinion to explain the examiner's thinking of why he found those pieces of prior art. And that gives you a sense of, is it worth it? Is it not worth it? Maybe if it's not so worth it, we'll only file in a few countries. Maybe if the examiner, the PCT examiner says everything's allowable, has happened, then you'll file in more countries. That hasn't happened so much. People generally file in the countries where their markets are, where their competitors are. But it's a way to help you make that decision, to make a decision if this, if you're going to get protection for this invention. And it's also a way of sort of putting off all that it's called national phase filing. You see that here, GBN is for Great Britain National Phase. You put all of that off until later. Could be that you're no longer interested in this product, so why spend all of the money? It gives you a little bit more time. 2.5 years is a better timing for budgetary reasons. The other thing the PCT does, and they're not the only thing, most countries now publish the applications at the 18-month point. 18 months from when? From this priority filing. Not everything follows from the priority date, but these dates that we're talking about now do. So your invention will be made public at the 18-month point from priority filing. It's something important to know about because sometimes you won't be ready for that publication, and that may mean you should shift when you make this initial filing. Okay, so now I just want to go back a little bit to provisionals. The provisional application does another thing for the US, which is it shifts the timing a little bit. So patents, nowadays, it's 20 years from the day you file. You get 20 years in every country where you file. So all of your foreign filings, Israel, PCT, Europe, they're going to live 20 years from the day that you filed there. Okay, which is, we know, 1 year from your provisional application. The US application, because in effect you refiled in the US also now is it's actually 1 year to 21 years. So the provisional application allows the US application and the patent when it issues to have the same timing as all the other countries. And note that I have the PCT here. All of the patents and all of the applications that issue from the PCT have the same timing as the PCT. Their filing date is the day the PCT is filed. That's how the PCT works. So now the question is, and it was kind of Ella's question, should you file a provisional all by yourself? Because I said they're really easy to do. The system doesn't require a lot of documentation. Everything works. It's lovely, right? And there are many people who have come to me after they've done this. It's always not such a good idea. That have filed their provisional applications all by themselves. There's a problem though. I may have given the impression that you can file anything you want at the Patent Office. That's not proper. Provisionals are defined as full patent applications. There's nothing in the law that says they aren't full patent applications. And so the biggest issue isn't so much in the formalities of the structure of what it should look like. There should be a background and a summary and a description, note, sort of standard for real patent applications. The bigger issue is what's in there, right? Everybody always writes what the invention is, what the idea is that you have. What are you going to do? But very few people naturally will describe how to implement it. What are the details of what you're planning to do? Sometimes because at the time that you prepare your first slides to go talk to a VC or go get an investor, you don't know the answer to that question yet, or at least not well. But sometimes you don't want to tell anybody yet. A, because these slides are when you're going to present it in some sort of public forum. But B, you don't want to give that information out yet. Think about Coca-Cola. They never told anybody how to implement their Coca-Cola drink, and they've kept that secret as a trade secret for many years. Problem is, that's not how the patent system works. The patent system is a tit for tat. You get a patent, you get a monopoly for 20 years, okay, it's only 20 years, in exchange for explaining to the world how to do your invention such that other people can do it at the end of the 20 years, or if they license the technology from you. So you need, and this is true for that provisional application as well. If you don't give that proper disclosure, that provisional filing doesn't protect your later disclosure. So if I go back, give me a sec. Go back. Remember we said you file a provisional application, then you disclose, and then as long as you file your full application afterwards, your disclosure isn't a problem. All of this is predicated on the fact that your provisional application is a full disclosure. You've described everything that you need to describe in order to cover what it is you want to have in your full application. What happens if you didn't describe everything? So this date goes, and now you have this publication before your US application, right? Before you file the full application, and truly also before your foreign filings, right? So in the US, we said grace period holds, and so we don't really have a problem vis-a-vis your US application. But if your provisional, let's call this now the provisional application, isn't good, and you published something in some way at this point, then all of your foreign filing applications have a problem, okay? So you have to be very careful about the information that you put into a provisional patent application. You have to make sure that you have it right. Now, the other things that do-it-yourselfers get wrong are the formalities. You know, the filling in the form for filing it, they probably get it mostly right, although trust me, we've had a few that went wrong. But there are other things like making sure that there is an assignment, even though it's not required, so that the ownership is registered properly. And so when you get to that due diligence, you don't have a problem with your provisional. Addresses go wrong. People don't pay their filing fees in some way. Something or other, the patent office sends them a note and they miss it and they don't fix it up. And then but trust me, we've seen all of the ways it can go wrong. But those are minor details. That's not really the problem with provisionals. Now, Ella wanted to see a budget, so I pulled some data out of my system. I hope you can read this clearly. The provisional application, you can see that in this case, we filed it in 2017 in shekels here. So we charge them about 7,500 shekels for dealing with, reviewing their provisional, writing a claim or so, handling their administration and the filing fee. Okay, so some people may charge less, but this is what we charge for this particular client. A year later, in 2018, we drafted the text. We wrote the whole thing out. This was about I think it was about 70-page application. So it's a fairly long, involved text. Then we did the foreign filings. In this case, we filed US and PCT. That covers the world and gives us advantages vis-a-vis the US. And then a year and a half later, so it fell into 2020, early 2020, then we filed it in 5 different countries. So that, is about 71,000 shekels. So to give you a sense of what happens, when you file a provisional, your initial costs are fairly low, but you move all those costs into the year, you put them off for a year, and then the drafting falls at the same time as the foreign filing, making that whole experience a lot more expensive. You could split this activity in 2, move it earlier if you didn't bother with the provisional, but most people want less expensive at the provisional point, and they're willing to accept the expense later on to handle the US and PCT filings, and then, a year and a half later do their what we call national phase filing. Now, just to give you a sense of the other costs, we go through examination. The examiner is going to tell us, you wrote the claim wrong, you're missing this, I found some piece of really close prior art, like we talked about. It takes something on the order of 8,000 to 15,000 to respond to each examination report. Depends on if we're talking about in another country where I work with associates, or if it's something that I take care of and file myself. And each country, some countries are slower, some countries are faster. So you'd have like 1 to 3 reports per year per country. They generally start about 2 years to 5 years after you filed in that country. So if you look at the whole schedule, we did provisional filing, we then filed into the PCT, we then filed national phase filing, that's 2.5 years. Add another 2.5 years, it's about the 5-year point that you'll start getting a lot of examination reports, because each country kind of like wakes up and says, oh my goodness, we're late. So there are also, strangely, a lot of incidental charges. We have to provide the patent office with copies of documents that you know about. You'll change your company name. Your inventor will complain about a spelling. There's lots of different things that happen along the way. You'll have a big exit, and we'll have to assign the rights to the new company. Whatever the arrangements are, there are a lot of other costs besides the ones that I've listed here. That, in a nutshell, takes care of the important timelines. They're not really movable dates. So realize that when you file your provisional or your first filing, you've set the timeline for the next 21 years, right? So you file a year later, whether you like it or not, you have to be ready to handle the drafting and the foreign filing. And then if you're doing the PCT, in another year and a half, another big amount of costs, because you need to file in lots of different countries. The longer the application, the more expensive. The more claims you have, the more expensive. This was, as things go, a relatively inexpensive application. I have seen much more. I had one client where we filed initially in 20 different countries, and it was about $100,000, not quite, but about $100,000 just to file at national phase from the PCT. And then he paid me $5,000 a month to deal when we started getting examination reports up from all over the world. It's a very expensive process, and invariably the 1 year and 2.5 year deadlines show up and get in trouble. So you have to be prepared for them and put them into your budget.
Heidi?
Yes.
Yes, we've had a question that this might be a good time to answer for clarification.
Okay.
Just wondering why you really need both US and PCR applications, and could you delay the US application?
So in general, we suggest filing US and PCT at the same time. You don't have to. The PCT includes US, so you could file just your PCT if it's less expensive that way. However, if the PCT gains you a year and a half and loses you a year and a half, it depends on what you're looking at. If you're looking at costs and putting off costs, PCT is great, puts off costs. It also puts off the time that you actually start examination, and that means it puts off the time that you're going to get allowance. And some people, for various different reasons, you want allowance. Some people want it earlier, some people want it later. But you do want to get allowance, particularly if you're a startup. And you need to explain why you keep putting more money and more money and more money into your patent budget, and you haven't gotten an issued patent. And without an issued patent, you can't really go and argue with anybody. So the US system in general gets to examination earlier. So we like to get a US issued patent earlier, and then the PCT countries tend to be, they're not all, but tend to be slower, and in any case, we've pushed them off. And so we can, if we've got an issued US patent, we can then say to the examiners in the other countries, hey, we've got a US patent, could you please give us a patent that's very similar to it? This works, this doesn't work, but it enables us to sort of begin to see what the picture is in terms of allowance, and then to reduce the charges in other countries, because we can say, hey, we've already got it allowed, give us something similar. And sometimes they do, sometimes they don't. You don't have to do it. There used to be advantages in terms of publications. Nowadays, the law changed and that wasn't. But the original reason that we did it was because the US didn't consider other publications the same way that they considered US patents and patent applications. But that law has changed, so that part of it isn't relevant anymore. Okay, any more questions before I go on to the last section?
I think that's it at this point.
Okay, no problem. I wanted to talk to you about infringement versus patentability because it's a concept that many people get confused, and when you're running the business, you need to understand the two of them. So the first thing you need to know is that patents enable you to keep people from making, using, and selling, and that includes importing your invention in the territory that we're talking about. So imagine in the US, it's a negative right. It's not a positive right. The fact that you have a patent doesn't mean that you can make your product that has that invention in it, fully. You can make your invention, but you might be standing on the shoulders of other people. So if your invention says you need a screw, you didn't invent the screw, you're using a screw. So you need to pay for, if it was an inventive kind of screw, you need to pay for that screw. That's what I mean by you're standing on the shoulders of other people, okay? I'll give an example in a minute, but infringement asks the question how similar your product is, your product, not your invention, your product is to the claims of the cited patent. So whatever patent that you're looking at, because somebody gave it to you or because you found it, your question to yourself is, okay, I'm looking at the claims. Does my product fall within the scope of what's discussed in those claims? So it's a question of how similar you are. Patentability, though, asks the opposite question. It says, what's your difference? What is your step forward? It's an inventive step. Compared to not other people's claims, compared to other people's descriptions. And this is not just in patents, although that's what I wrote here. It's also other kinds of disclosures, things in Wikipedia, on the internet, articles of any kind, newspaper articles, scientific, academic articles. where the question is, what did you do new? That's a step forward. And we're always talking about, so what's your difference? Is it a patentable difference? Is it is it enough of a difference to make it worthwhile to write this patent? So that when you look at a patent and somebody brings a patent to your attention, you're basically asking yourself two different questions. Oh, I'm patentable over that. That's easy. But then when you go to look at the claims, you have to say, oh my goodness, am I doing the same thing? Okay. I have an example. I'm the inventor of the wheel. I'm an old lady. And you're the inventor of the bicycle. Now, clearly the bicycle is patentable over my wheel, right? Why? There's a whole structure here, right, of the metal frame structure of how the bicycle holds the two wheels together, and the pedals and the chains and the sprockets and all that stuff. And there's wheels, and they're not just any old kind of wheels. They're rubber tire. They have rubber tires. They have metal spokes. They're very light. They're disconnectable. Not in this picture, but you can imagine. So clearly, there's an invention somewhere in that bicycle. Okay, and that's a difference. That's a step forward, certainly over my silly wheel. But you're using the technology of my wheel, right? You have a round outer surface and a round outer rim. You've got spokes. You've got an axle for it to rotate around. So assuming that my patent is still valid, we're still within the 20 years of my patent's life, you're standing on my shoulders. You're using my technology. And therefore, you should pay me. You're infringing my technology. Now, if you buy the wheel from me, then you don't owe me any extra money. You've bought the wheel. That all of my rights against infringement are used up in the process of that buying. Or you could license the technology from me, and the license would be for however long, for whatever country, however we want to set up the license. You would pay me a certain amount of royalties for the fact that you're using my patent. When my patent expires, you're free to make generic wheels. So keep this picture in mind when you find a patent and you think, oh my God, I'm infringing that patent. I can't write my patent application. That statement is incorrect, most probably. You're infringing their patent because your product does the same thing, but your product might have some interesting step forward. I don't know what it is, but it might have some interesting step forward that is still a step forward. Yes, you're using my wheel, but you've made a bicycle. So when I come to tell you, you're infringing my wheel, you can say, but wouldn't you like to make a bicycle? If you want to make a bicycle, you owe me money for my bicycle patent. And that's the cross license I was talking about at the beginning. One of the ways to reduce down a license for the technology that you need because you're actually using it is by doing this cross license, giving the other side rights to your invention. And that way everybody's happy. The other side I get to make a bicycle and you get to make a wheel. Which one of us will actually exchange money with the other? Depends on how the license goes and who thinks who's got the better invention. Just to summarize, you need to plan a strategy. You need to know about IP. You need to know about IP schedules. Particularly in this case, I'm talking about patents. There are timelines for the other intellectual properties that you will need to know about, but here I'm talking about patents. You need to plan strategy, how you handle your copyrights, how you handle your trademarks. And with copyrights, it's critical that you make sure that your contracts transfer the rights in the copyrights, the copyrighted work. If somebody make your website for you, you want that, you need the ownership to come back to you, signed on the dotted line. You use it as insurance against future IP rights. That's what my client didn't have with Lucent. But what Saifan did have when they went into their IP fight, they had IP that they could use. Most Israeli clients, most of my clients do not actually go into IP fights, but they have their patents so that if they need them, they can have them. And unfortunately, more is better than less. Notice I told you timelines are fixed from the day you file your first application. That application has its schedule. Your next application has its schedule. Your next application has its schedule. If you filed 3 applications on the same day because you have a product that's going out the door and there were 3 different inventions inside of there, that means a year later, you're going to have 3 applications, each of which needs to do foreign filing, either US and PCT, just PCT, none of that, you just want to file in Europe, whatever your strategy for filing is and what makes sense. And if you do the PCT, a year and a half later at the 2.5-year point, all 3 of those applications are going to go national phase into 5 countries, 10 countries, whatever your arrangement is. So you have to be aware and time your applications. Now, sometimes you can't time them because they depend on each other and you don't want one to be prior art to the other. So you file them on the same day. But that means they march in step and in terms of your timelines. And as you can, that's what's clear from my discussion, you should be prepared for the expenses, know when they're going to happen, and get your patent attorney to give you budgets to the extent possible for the work that you're going to have. So if you have any questions, even if you don't, please ask them now if you come up with another question. So you can contact me, and my address is HMB for Heidi Michelle Brun at HeidiBrun.com. I also blog at the Patent Pen, .patentpen.com, sorry, a little boring. But I don't talk about legal issues so much as the process of being a patent attorney and being a client, and the things you need to know. This talk was pulled largely from an article I wrote, and that is on the blog. And I talk about, various different issues that come up in the life of dealing with clients and the issues that they have. So, anybody have any questions?
Somebody's asking about fees after the patent grant.
So there are, they go by the name of annuities, renewals, and maintenance fees. In the US, they're called maintenance fees. And they have to be paid by the end of the 4th year. So it issues 4 years later, you have to have paid them. The first one, 8 years later, and 12 years later, if you actually had 12 years left on after your patent's issued. Some do, some don't. In general, you start paying them at the a half year earlier and have an extension. In some countries like Europe, Brazil, and Canada, I believe, you have to pay every single year from the 3rd year. Starting in some it's the 3rd year, some it's the 4th year. And those are called annuities because every single year you pay to keep your application still alive. Even though the examiner hasn't looked at it yet, in Europe they're really terrible, other countries a bit better. You have to pay to keep the applications alive. Other countries like in Israel, you don't pay until it issues, but there's a schedule for all the years, for all 20 years, and you just start at whatever year you're at. So if your patent issues at, say, the 7th year, then you have to pay 1 through 10, because that's the schedule. It's 1 through 6, 7 through 10, so on and so forth. But yes, they're expensive, and what you'll discover is that when you first start working on patents, all of your work is in terms of writing the applications. Your costing is for writing the applications. It gradually shifts, and you're not just writing applications, but you're also responding to examiners. So you write less applications because you have sort of a fixed budget. And then as your applications go into either are issued or go into the countries that have annuities, now you have to divide out that budget to give you a chunk also for annuities. And as your patents issue, it's more and more just the annuities. So it shifts. And in general, young startups should file 1 to 3 applications a year. The older companies, it depends on what they're doing and how much they're still expanding. When you have a research project or really a development project, you'll have a whole bunch of ideas all at once. So we will write those applications, and then a couple of years will go by as things settle. We do the filings abroad, and then you have another bunch. What I've seen for most clients.
Heidi, I want to ask you about wartime. A friend of mine went public, was trying to go public on NASDAQ, and 2 weeks or 3 weeks before IPO, he gets a letter saying, "You're infringing our patents. We're going to sue you." What do you do?
Cry. First reaction is, oh my gosh, panic. And then settle down to sort of decide that what is true is that the bigger you get, the more visible you are. And when people see that you have money, they go, I'd like some. So you get a lot of these sort of nuisance things, and invariably they show up right before that big deal, while you're in the middle of due diligence, any of the times when you really don't want them. What you do, first of all, is read and decide whether or not the person is right. Maybe yes, maybe no. Most of the time there is a similarity, but not enough of a similarity that you can get out of it. You know, like if you read the claims really carefully, the definition of the invention doesn't quite cover you. So with that knowledge, you have to change your IPO description. The IPO description lists a whole bunch of risks. You know, nothing has no risk to it whatsoever. So there's a risk that, you know, the company will run out of money. There's a risk that they'll go into a market that's not really ready for them. There's lots of different risks. And you add, there's a risk that this guy's gonna cost us a lot of money. And you can say, but we have a good argument. In other words, you can present, you have to present your answer back. You don't have to answer this guy, but you have to give your answer to the public that is thinking about investing in you, and add it to, you know, the list of problems. Now, if it's a really close prior art that wipes out a significant part of what it is you do, probably put off the IPO until you've pivoted or paid the guy some money, but you need time to negotiate with them. And, you know, hopefully you have enough money to get through that problem. Sometimes yes, sometimes no. We have a friend, just as an aside, we have a friend who went out, who was supposed to go do an IPO just as the stock market in the US crashed many, many, many years ago. And his company died because his timing was, unfortunately, really bad for no reason of his, you know, like nothing to do with him, but he'd run out of money at that time. So it's that kind of a thing. Like if you can just keep going for a little longer, then maybe you can solve the problem.
Yeah, Heidi, I'd love to ask you, you know, there's a really interesting line of thinking around patents that, especially early stage, sometimes you'll hear investors, the investors that have a lot of money, the venture capital side might say, I don't spend money on patents, just go to market fast, just get there, you know, that's how you win. And, you know, we clearly see, I think the best cases are combinations of those. I think probably an example like Uber, where they had so much money thrown at them, people think twice about trying to compete or copycatting, although they did a successful copycat in Asia. But can you give some advice on that to a startup when they're thinking about, you know, how critical are my patents? And, you know, maybe, I mean, I think you've done a beautiful job already of outlining the timeline, and the costs are really reasonable. So, but maybe just what has your experience been from the investment community?
So to some extent, this is you know, against my interest. I'm a patent attorney, so I apologize. But I've seen people do that. getting out to market, and nowadays I had a slide and took it off about the COVID, right? How do we handle this crisis and the fact that we need products out there really fast to solve various different issues? What do? You waste your time chatting with a patent attorney so he can write it up or she can write it up, and the whole process just adds a whole lot of time that you don't necessarily want to spend. So you can go out to market. You can, be there, be very speedy, know that you're always going to improve on your ideas and constantly run faster than everybody else. I did have a client that did that. As long as eventually you're going to have to do patents, is the answer. Eventually you're going to be too big and people will come calling. If you have a nice war chest that you can just hand at these people, it's no problem, that's another solution. But they're going to come calling and you're going to have to handle it. The other thing that I saw in this particular client that I went to, you don't realize there's corporate memory. And so an idea you have, the basic structure, exactly the same thing. But you take that idea and, change it around a little bit, but that core of an idea passes through an awful lot of your products. Sometimes it's, the first version, the second version, the third version of the same thing. And sometimes it's you take the idea and you make, this use case, that use case, another application, and it's not exactly the same idea, but it's moved. But there is this core concept. So you can use it, you ought to be doing something. There's also more in my field than in the pharmaceutical field. I don't do pharmaceuticals. I'm not non-life sciences. I can do, I'm a mechanical engineer. I can do anything mechanical, software, electrical. I did sci-fi stuff, semiconductors, anything, math, but I don't really do the life sciences. But in my world, things change. The product, the idea moved through, the later product is a different product than the earlier one. And so I can make a claim on this new product. So we didn't patent for 5 years. Okay, we didn't patent for 5 years. We can start on whatever new idea you have now, and it won't be a broad claim. But as I said at the beginning, you don't need always to have the broadest claim. You can have a claim on the product you're selling or the invention inside the product that you're selling, and you can just work with a narrower claim. So in fact, you're answering a question that we didn't bring up, which is, well, what do you do if you miss your 1 year deadline, right? You didn't make it, you didn't have the money, you couldn't do it, we couldn't write the application, Heidi's much too expensive, or some other arrangement like that. What do? Well, usually, especially for startups, the idea that they originally had has changed. It's morphed into something else. What the something else is, I never know, right? But it's morphed, and I can, instead of moaning over spilled milk, we can just write a patent application on what you have now, and claim, what you're actually producing, because that's what other people want. They don't want the big idea. They want to make a copy or something close to a copy.
And Heidi, just building on that, I noticed two things. One is there's a question which I think is going to lead to this laddering effect. Is it possible to extend patent life to upgrade the patent, something along these lines? And you might want to comment on how you can ladder your patents so there's something that's still alive. And Hamatal, I think, is that how you pronounce your name? Yeah. Yeah, feel free to add if you'd like to. I see you've been actively asking good questions. Go ahead, Heidi.
So yes, and less so than there used to be. Back when I first started, it wasn't 20 years for patent life. It was, in the US anyways, it was 17 years from issue, which was usually about 20 years anyways, because it took about 3 years to get through the patent office. But you could file something else and something else and something else and extend patent life. That went away when they went to 20 years. In the US, they'll give you extensions for the patent office being slow and a few things like that. It adds a few years one way or the other. But all of the children of a single patent application all more or less end on the same day. So in terms of extending patent life, not really. But what you can do instead, there's this concept of children application. You file a first application. This is within countries, not across countries like we talked about before. Within one country, if there's, in the US, you can file what's called a continuation application, which claims not exactly the same thing, but a slightly different version, maybe a broader version of the claim or a very specific version of the claim. There's another kind of child application, which is called the divisional, which is a split. If you actually had two ideas in the same application, the examiner will force you to split it out, or you can choose to split it out yourself. So there's another idea that's very common in the US called the CIP, continuation in parts, which is you have an original application and you're making another version of it. Like, it's not exactly the same, but it's sort of the same. It uses the same concepts, but it somehow or other doesn't quite fall under the original set of claims. And so what you do is you take the old text and add a whole new description. It gets a new date because there's a new description, but it's also tied to the old one. So formally, the old text is not supposed to be brought as prior art. That's the reason you do it. There was a recent decision that kind of messes that up, but we'll ignore it. So the old text has the earlier date and the new text has the new date. And you can add that, but the problem is, once again, you're still stuck in the same 20 years. So you're not really extending life. What you do instead is you have this new embodiment, this new bit that you're interested in, just file on that. And so it's a new concept, it's a new version, it's a better version. Think about your product, you put out the first version and then you do another version, and your product gets better and better. That's the advantage of our world over the chemical world. You can't upgrade a chemical. It's itself. You can, maybe add other things into the mix, but you can't change the chemical itself. Our products, you can change them. I don't know, I've got a Galaxy S10, there was S1, 2, 3, 4, and 5. Like, each one had their own features. So for each of the different features that you add onto the Galaxy, you would write another patent application. And you hope that there's enough of an inventive step that they're actually different. And that's one of the things that we measure. Is it really different? Does it fall within the claims? Do I need to write a patent application on this? Those are the kinds of questions that we ask when we look at the next version of the application.
Heidi, someone's also asking about, excuse me, about the app world and IP.
So I actually gave a talk about this a few years back and wrote on the patent pen. Mobile apps in many ways answer one of the questions that comes up, which is software patentable? Now, I've been in the business over 30 years, and the question, is software patentable, has been a question for all those 30 years, and I've been filing patent applications on software inventions for 30 years. So yes, no, depends on the current decision. Once again, the main question is always, is it really patentable? Is there a significant difference? Are you using the elements and the features that you have on a mobile phone, for instance, or a tablet, in ways that nobody else has ever used? Are you using it for purposes that nobody else has used? Have you changed market? All of those things help make something patentable. Software isn't patentable. Nobody, they call it software per se, i.e. the actual code. You cannot patent code because it's just data. You can patent a software product. And generally, the way you do it is you tie the software code, not formally, but in the way that the Patent Office thinks about it, to the actual hardware, right? So some patents I've gotten, like I had one where it was the fact that we had a GPS there that provided a certain, that the company used in a way that was never used before. So the fact that I had a GPS, which is a hardware kind of element, made that invention more patentable, even though it was really an awful lot of software. So that's the kind of thing that you can do. One of the things that I haven't really said is that, what do you do if you can't? If the answer to your question, and we sit down and we look at your product and we go, I don't see how to make it. There's nothing you're doing here that isn't sort of moving data around and doing nothing interesting that the patent offices think is interesting. So then we move to the other kinds of intellectual property, because patents isn't the only kind of intellectual property. And you want to think about them. You want to think about designs. You can do designs on apps. Okay, I happened to be at the USPTO right after Steve Jobs died, and they had an exhibit about all of Steve Jobs' patents, and it was huge. He had loads and loads and loads, but a lot of them were on designs, on the particular design of the iPhone that was so interesting. The rounded corners, on the logos that they use for all the different apps, all that sort of stuff. He'd registered design apps for, and everybody copied them, right? Samsung versus Apple, right? That big court case was there because he kind of thought through what the screen should look like and how it should work. So a design might be the solution to your problem. And then there's always trademark, which is your brand and how the name of your company, the name of your product, and how you brand it. Think of Dunkin' Donuts, right? Dunkin' Donuts has, their colors and purple, is it purple or pink? Is here, and their gold is over here, and they always use the same furniture structure, things like that. Like, all of this helps people know that they want that product, and that's really what we're trying to get at. Remember that the purpose of all of these different kinds of protections is to is for commercial purposes, not just because we feel like we're so proud of ourselves for making an invention. It's to help the business move, and so any way that you can cause people to buy your product and not somebody else's product is worthwhile.
Great.
Questions?
I want to add a few words before we invite Gwen to speak about a little more about what this Foundry is all about. And I want to thank everyone that was involved in making this happen. And first and foremost, Ellen Schnitzer, who's here on this Zoom meeting. And Ellen is a public diplomacy expert of the US Embassy in Jerusalem. And she has a really, really important role in the fact that we are here. So thank you, Ellen, and thank you for the Embassy and for the US Department of State for supporting our incredible activity, She Entrepreneurs activity this year. And thank you to Lori Confino, who was the first commercial supporter after the US Embassy. A big, big thank you. You saw a glimpse of Lori in the event we had 3 weeks back, and we will see her again and again throughout the course. I want to thank 3 other bodies. This is Discount Tech of the Discount Bank in Israel. They have a new offering to startup companies, which is actually pretty incredible. I want to thank IBI Tech Fund, which is a very, very interesting concept that they have run so that, anybody can invest just like a VC, and you can go and buy their fund on the Tel Aviv Stock Exchange. I want to thank Brainu, an amazing marketing agency, marketing digital and marketing creative. We had a fantastic time with them. And last but not least, I want to thank Heidi Brun Associates for their support in this program. I want to remember to say thank you. You deserve it. And I'd like to hand it over to Gwen now to speak about the homework that are involved in this program, and for good reason.
Okay, thank you, Ayla. Just one final comment on IP, because it's quite fascinating to realize you really don't know if people are going to care or not about your patents until you least expect it. So you heard about pre-IPO. It could be, oh, you're trying to negotiate a licensing agreement. And then you find out in the course of that, the person was actually picking your brain. And you think you have a deal, and the day before you have the deal, you find out, oh, it's off the table. And if you didn't have the patent protection, you'd still have to go after them, but you're really in trouble. But even imagine not having any issues until after your company is acquired and dollar signs are published and people know, oh my gosh, now that entrepreneur has big money. Someone out of the woodwork comes around and says, wait, oh wait, back in the day, we have evidence that you did X and blah, blah, blah. So you just don't know. And I think, even remember Zuckerberg and Facebook, his co-founder that he denied existed, didn't come after him until he had money. Like, why bother? But when you're successful, that's when you really need to make sure you protected yourself. And that's why I just wanted to reinforce, and I love Heidi's timeline. It's think early, the early stage about how to protect yourself. And as you grow and build and have more capital and more success, you'll keep weaving that knowledge and those protection mechanisms into your process. So thank you again, Heidi. It was great to hear. And I like the appreciation, the comparisons between Israel and US and how we can work together to give some good advantages to the companies that are starting today in Israel.
My pleasure.
So, yeah, thank you. So just a little bit more about our course. I mentioned that we're going to be talking about how do investors think. And at the end of each class, there will be homework actually to prepare for the next class. So a little bit of digesting what you've learned and then preparing for the next class. And we have a session on value proposition. How do you get good customer product market fit? And that, by the way, it's really interesting that we're confident there will be people in the class that are early stage and later stage. And yet each one of these courses is really relevant, almost independent of stage. There are tweaks to it, but you can think about defining, working on your business model. And do you have the right business model? How have you been creative in that process? You want to do that at the beginning, but also think about big companies like Amazon or Apple. They've refined their business models so many times. They're not the same company they started out as because they never got stale. They reassessed. They did more product market fit for a new idea or a new approach. So getting those skills and mindset into how you approach your initiatives and inventions and companies is just really useful. It's like building muscle that you can use again and again. And then we also have a whole session on market. How do you define your market? And it's not just big picture market, but if you're early, how do you get that first customer? If you're midstream, your first customer for that new market. So it's understanding big picture market and early, make it real. It's one thing to say, in fact, one thing you don't want to say is, oh, I'm going to just get 1% of that bazillion-dollar market. That's a turnoff because the reality is, great, how are you going to do that? Where is that first customer? So it's a nice blend of big picture and real gritty, nitty-gritty work. And then we have a section on building your we call it the MVP, most valued player team, but how do you really build the right team? What are mistakes that you could make that you need to avoid early that could really hurt later on with respect to capitalization, issuance of stock, things like that. And then a whole session on understanding your financials. How do you build a financial model? But how do you really understand what capital you need? It's a big question that comes with each stage in your growth. Always raise a little more than you think you'll need, but how do you really do that and have milestone achievements that will allow you to increase your valuation each time you need to raise money? So it's understanding financials in a very practical way. And we also then have a class on term sheets and kind of the tech transfer, legal issues associated with terms. That class could be a week long, but we'll give you the high level, what things to watch out for when you're presented with a term sheet from an investor, and how to be alert and as well informed as possible. And then last, how do you pitch? And this is really, it's not just about learning techniques, but really getting into the details of what is your core value prop? How do you express that? And how do you get people really excited about what you have to offer? Because that is so important. And a pitch, as they say, isn't really just an exercise for 10 minutes. It's how you are deeply aware of the value you're creating so that you can make that pitch when you bump into somebody in an elevator and you find out, oh, they're at the angel investing conference on the 10th floor. Oh, how great. Well, just let me introduce myself. You might have a business card. You capture their attention. So it's how you pitch to a future employee. You want to hire somebody. So you're constantly, when you're the CEO, you're always meeting people when you least expect it, and sometimes it's planned, but you want to have a comfortable way of making sure you can adapt and represent your company. That's exciting, so that people join you and want to build and support and help. So that's really the last, and then we have a day we prepare for where you'll be able to stand up and deliver that pitch. So in the spirit of pitching, at our next session, one of the things we'll do is ask people that are in the class going forward to give just a 1 minute, could even be a 30-second pitch. Your name, the name of your company, and one sentence, maybe two, that get people to go, wow, I want to make sure I follow up with her. Or there's a coach, coach.com. They actually have a template, and this will all be provided in advance, but there's a template on how you actually craft that 30-second or 1 minute description. It sounds easy, but it's not easy because, and you'll see when you're asked to do a 3-minute pitch, that's really hard because you're trying to get everything about your company. We currently have 500,000 in traction, 300,000 potential customers, blah, blah, blah. You're trying to get everything in a few sentences, but that's a fantastic exercise to do at any stage in your business. So that will be the homework for next Wednesday. We'll actually start with that, so you don't have any time to rest or relax. We want to just make this jam-packed so that 8 weeks from now, you're really feeling comfortable, confident, and building your business. So thank you. That's really all I had to add at this point, except I want to make sure Gail has a chance to say a few more words. We're co-teaching, and she's been quiet during this session, but you'll hear a lot from her in the weeks to come. Gail, did you want to add anything? She's
Sure,
the homework queen.
No worries. Great to meet all of you. And again, thank you, Heidi, for a wonderful survey of the IP landscape, comparing both Israel and US. That's really helpful. We will reinforce more of that as we delve into how it might apply to the femtech industry, biotech, and some of the digital health phenomena that are going on that we see morphing over time, and how that would change a person's or the founder's IP strategy over time. So with that, yes, Gwen, thank you for the sort of construct of what the course will look like. And I just look forward to meeting you all and working with some really wonderful companies and the outstanding mentors that Isla has pulled together.
Great. Yeah, Gail has some great war stories on IP in life sciences too. So yeah, we'll have a lot of fun. Are there any other questions?
Thank you, Gwen and Gail.
Yeah.
Throughout this course. Thank you, Heidi, for an amazing talk about IP. So interesting, makes you want to think it's not that boring as we thought initially.